All right, we're on the record in docket 22-02511. People of the state of Michigan versus Anthony Frisson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender, here on behalf of Mr. Friesen. Mr. Friesen is present. He's at council table, seated to my right.
And sir, you are Anthony Frisson?
Yes, Your Honor.
All right. This is the time set for a preliminary examination. Ms. McComber, how are we proceeding?
Your Honor, we will be proceeding with a preliminary examination today.
All right. Are there any preliminary matters to come to the court's attention before the preliminary examination begins?
I have two, Your Honor. I've informed Mr. Starks of both. The first is that upon appropriate proofs, the people will be seeking to add an additional count of assaulting, resisting, or obstructing a police officer.
Find over will include an added count of Arno.
Correct.
Okay.
And the second, Your Honor, is a little bit different. So count 2 is currently charged on the complaint list that the defendant did without just cause commit a reckless, did threaten to knowingly kill or torture a kitten. While that is one of the theories of animal killing or torturing in the second degree, the actual theory that should have been listed is that the defendant did threaten to knowingly kill or torture a kitten who is a companion animal for the purpose of exerting control or causing mental distress.
Same MCLA code.
It is, Your Honor.
All right, and you can readdress that in the if and when you make your motion. Okay, but I wrote it down. So the notice has been given to defense counsel in regards to adding a count of resisting, obstructing, and maybe amending a count in regards to the count 2. Mr. Sark, anything from the defense in regard to either one of those notices?
Thank you, Your Honor. I'll reserve my arguments in rebuttal pending the alleged evidence presented here. Of course, I expect I would be objecting to both, of course.
Right.
And from our side, I would just ask for the standard sequestration order, Your Honor.
All right, and I don't see anybody in the courtroom other than the LPD officer. So at this time, sequestration is not an issue. If somebody comes in, I'll leave it to counsel to make me aware of that. Anything else before we get started?
Nothing from the people, Your Honor.
Anything, Mr. Sarks?
Nothing further, Your Honor.
All right, Ms. McComber, you may call your first witness.
Thank you, Your Honor. People call Officer Ashley Anderson.
Hey, Officer Anderson, I'm going to have you stand right in front of me, dude. And for my court recorders, please indicate your, please state and spell your first and last name.
My first name is Ashley, Ashley. Last name is Anderson, Anderson.
I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, you can have a seat right here. And I'd ask you just to project for the recording. Ms. McComber, you may proceed.
Thank you. Officer Anderson, I'm going to have you state and spell your name for the record.
Yes, ma'am. My first name is Ashley, Ashley. Last name Anderson, Anderson.
And where are you currently employed?
I am currently employed with the City of Lansing Police Department as a road patrol officer.
How long have you been with the Lansing Police Department?
Almost 2 years.
In your role as a road patrol officer, what are some of your duties?
Responding for calls to service, patrolling the streets.
And were you working on July 29th, 2022?
Yes, ma'am.
What shift were you working at?
Noon shift, which is 3 p.m. to 1 a.m.
At some time during your shift at about 6 p.m., did you receive a call for service to report to a 824 Conrad Street, apartment C5?
Yes.
Is that in the city of Lansing?
It is.
Ingham County?
Yes, ma'am.
And what was the purpose of your response to that address on July 29th, 2022?
Original complaint was a PPO violation.
Were you able to determine who the person calling was,
Yes, I was.
who the complainant was?
Yes, both the complainant and the original caller, I was able to determine who both they were.
And who was the complainant in the case?
Karen Stone.
Now, when you responded to the 824 Conrad Street, did you make contact with Karen Stone?
I didn't.
Upon making contact with Karen Stone, did you learn of anything that would cause you to do a further investigation at that address?
Yes, ma'am, I did.
What did you learn?
That she had a PPO order against Mr. Prison and that he was in her apartment.
You say Mr. Prison, is that Anthony Prison?
Yes, ma'am. Absolutely.
At some point during the pendency of this investigation, did you actually make contact with Anthony Prison?
Yes, ma'am, I did.
Did you recognize him if you saw him again?
Absolutely.
Do you see him in the courtroom today?
I do. He's right there.
Can you describe an article of his clothing?
Yes, he's wearing a gray shirt and there's white under it. White shirt under it.
Your Honor, if the record may reflect identification of the defendant.
Any objection?
Yes, on the basis of lack of foundation for now, Your Honor.
All right, thank you. The record may reflect that the witnesses identified the defendant.
Thank you, Your Honor. So Officer Anderson, you said that when you initially arrived, you learned there was a personal protection order protecting Karen Stone and that Anthony Prison was the person that was restricted. Is that correct?
Correct.
Did you verify that information in any way?
I did, ma'am.
How did you do that?
I did it in two separate ways. First was a paper copy that I received from LPD jail. Second was verifying it through the Law Enforcement Information Network, our leading system.
The paper copy that you were able to obtain from your jail, did it list an address at which Mr. Prison was not supposed to be at?
Yes, ma'am.
And was that address 824 Conrad Street, apartment C5?
That is correct.
Was there an additional apartment number on that personal protection order protecting that residence? Or protecting a separate residence, I should say?
Yes, there was.
Is that apartment C20?
Yes. That's correct.
You said you learned that Mr. Prison was inside the apartment. Did you make contact with him inside the apartment?
In apartment C5, yes.
How did you initially make contact with them?
Officers approached and were knocking on the door, and he came and talked to us through the door. The door was shut the entire time.
So initially, Mr. Prison never opened the door.
Correct.
Based on the interaction between officers on scene and Mr. Prison, was there any reason to doubt that the person inside that door was Mr. Prison?
Jack, on the grounds that we call for speculation, Your Honor.
Response?
I don't believe it's speculation. I believe it goes to the officer's investigation and why they continue to talk to the person behind the door.
I'll allow it. Overruled.
Thank you. Did you have any reason to doubt the person on the other side of that door was Mr. Prison?
No, yeah, no.
And in verifying the personal protection order, were you able to determine whether or not that personal protection order had been served?
Yes, I was.
And were you able to determine whether or not that proof of service was filed with the court?
Yes, I was.
The proof of service that you were able to verify, did that indicate that that personal protection order had been served on Mr. Prison on May 20th, 2022?
I'm going to object on the grounds that you're starting to lead the witness here, Your Honor. I've been allowing it to up to a certain extent, but when we're getting into these types of specifics, she's clearly leading the witness now. Thank you.
Sustained.
Thank you, Your Honor. Were you able to determine the date in which Mr. Prison had been served with that personal protection order?
Correct.
What was that date?
May 20th, 2022.
When you arrived on scene and you were speaking with Ms. Stone, were you able to determine the relationship between Ms. Stone and Mr. Prison?
Again, Your Honor. Leading the witness. Objection. Thank you.
Are you able to determine? I'll let you phrase.
When you arrived on scene and you made contact with Ms. Stone, were you able to determine if there had been any relationship between Mr. Prison and Ms. Stone of any nature?
Yes, I was able to determine
And what were you able to determine?
that they had an intimate dating relationship for about 9 years and had 3 kids in common, and that they both resided there.
And what was Ms. Stone's demeanor when you first arrived?
She was upset and crying and was holding a little kitten.
The kitten that she was holding, do you know why she was holding that kitten?
Yes, I do.
And why was she holding that kitten?
She was holding it because she told me that he had grown.
Objection. Hearsay.
Response?
Your Honor, I believe this would fall under 76827C. This does have to do with a domestic violence incident and an incident that happened within that. This portion of that is just beginning and it goes further into the dynamics of domestic violence that were being exhibited on this day.
Your Honor, the prosecutor has not presented the sufficient foundational requirements in order to bring in hearsay under that statute, so I will reiterate my objection. Thank you.
There are some foundational requirements that are required. I do think they've been met in this instance for the hearsay to come in pursuant to the statute and the case law concerning hearsay evidence at a preliminary examination. So for these purposes, I'll allow the officer to continue testifying with the understanding that it's a different level at circuit court. You may proceed.
Were you able to determine why Ms. Stone was holding the cat?
Yes, she informed me that Mr. Prison had thrown the cat over the balcony and she was just holding on to it because it was in pain.
Were you able to determine what was happening just prior to Mr. Prison throwing the cat over the balcony?
Yes, I was.
And what was that?
He was calling her, saying that if she did not come get the cat, he would throw it over the balcony.
And
I would object because one thing is lack of personal knowledge. How would she personally know this? Was this coming from a different source, Your Honor? Just the way that the question has been answered. Thank you.
You can rephrase.
well, Your Honor, with all due respect, I don't believe lack of personal knowledge would apply here. We have already indicated that this would be hearsay coming from Ms. Stone. It would be allowed under the statute, and going further, the next question goes further into what happened just prior to this, leading to the assaulted portion of this case.
The only thing I thought the objection was to the nature of the question, not to the actual answer of the hearsay.
Correct,
I
Your Honor.
apologize.
Yeah, the way the answer, yeah, exactly. Who was the source of this information? Where is this information coming from? Obviously, the officer didn't.
Correct. So,
I apologize.
all right. So if you rephrase, I think you can get to the same substantive material.
Thank you. Did Ms. Stone tell you what had happened just prior to Mr. Prison throwing the cat over the balcony?
Ms. Stone told me what happened.
And what did she tell you?
And again, I'm going to state my objection just for the record, Your Honor, to preserve it. I don't think the prosecutor met the foundational requirements in order to bring 768 evidence in. Thank you.
All right. With the objection noted, you may continue.
Ms. Stone told me that he had been calling her, saying that if she did not come get the cat, he would throw it over the balcony.
And just prior to that interaction happening, did Ms. Stone tell you about any sort of altercation between herself and Mr. Prison that happened inside of the apartment?
Yes, she did.
And what did she tell you?
And again, I'll stop. This will be the last time, Your Honor. Just but be a continuing objection. Thank you.
All right. With that understanding, the objection for the prelim purposes is overruled. You may continue.
Ms. Stone advised that she was in the apartment on the phone with her daughter. Mr. Prison came in and started asking her to get off the phone, and an altercation ensued from there.
And did Ms. Stone tell you how she got out of the apartment, or what led her to getting out of the apartment?
Yes,
And what did she tell you?
Mr. Prison had thrown her phone out of the apartment and she went out to get it. He then locked the door behind
Did
her.
Ms. Stone tell you how Mr. Prison got her phone initially?
She stated that she had the phone behind her back and he told her that he was going to kill her, smother her, and put her head through the wall. And then at some point, he got the phone
From Ms. Stone.
from Miss Stone, from behind her back.
Nothing further. Thank you.
Cross-examination.
So just to, when you first encountered Ms. Stone, approximately what time was this?
Approximately 6 o'clock that I was dispatched, so I would say only 10 minutes or so after that.
Okay. And what were the lighting conditions to the best of your recollections?
It was very light out.
Okay.
Weather was clear.
And when you encountered Ms. Stone, she appeared to be distraught to you.
Correct.
Did she appear to be intoxicated possibly?
Not that I could tell at the time, sir.
And did she ever slur words,
She did not.
or her eyes were glassy, or,
Not that I could distinguish from crying.
okay. Was she coherent in her responses to your questions? Did she ever trail off or,
Not that I remember.
okay? And in terms of your identification of Mr. Friesen, did you ever get any license information from him? Did you ever get any personal information from him directly or from Ms. Stone?
I obtained personal information from Ms. Stone and then ran Mr. Friesen and Lean and obtained a photograph,
Okay, what was that personal information?
name and date of birth.
Date of birth, okay, but nothing else?
No, sir.
Okay. And when you testified earlier about this PPO, was this a certified court copy? Were you seeing any indication in the document itself that this was a properly filed document?
Can you repeat that question, please?
Sure. You testified earlier that you saw an image of a PPO, correct? A court order?
Yes.
Okay, did you see some type of signature from a judge in that? Did you see some type of certification on the document? So,
I did. Yes, Your Honor.
okay.
Sure.
Thank you. And when was that PPO dated for?
5/20/22.
Okay.
When it was served.
And when you first responded, were there any other officers with you?
Yes, there were.
Okay, and who were those officers?
Officer Kilborn. And then I believe. I don't remember other than Officer Kilborn because I responded out there 2 weeks later with several other officers as well. But I know Officer Kilborn was there.
Okay. Thank you. Nothing further.
Redirect?
I just have one clarifying question, Your Honor. Officer Anderson, the defense counsel had asked you kind of a two-part question. He had asked you if you believed Ms. Stone to be coherent or if she ever trailed off, and your response was not that I can recall. So I want to separate those. Did you believe that she was coherent when you were speaking with her?
Yes.
Did her answers ever trail off or lead you to believe that she was incoherent?
Not that I can remember.
Thank you. Nothing further.
Without objection, is this witness excused
Yes, Your Honor.
from the defense? Or do you have a follow-up question?
May I just want to ask one brief follow-up question?
Absolutely.
Do you recall, officer, who served the PPO? Is that,
Judge Cohen,
you think that the judge served the PPO or signed it?
that signed it. I
Okay.
do not remember.
Who served? Okay, thank you. Thank you, Your Honor.
All right. Any objection to the witness being excused at this point?
No, Your Honor.
No, Your Honor.
All right. Without objection, this witness is excused. Ma'am, you can leave the witness. Thank you for your appearance.
Thank you, Your Honor.
Any further witnesses from the people?
Yes, Your Honor. People call Karen Stone.
Ms. Stone, I'm going to have you stand right here and I have to indicate your first name and last name for the record.
Karen Stone,
All right, and could you spell that, please?
STONE.
All right, you're gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, I'm gonna have you sit in that chair and please project for the recording, okay?
Okay.
All right, thank you. Ms. McComber, you may proceed.
Thank you. Ms. Stone, can you please state and spell your name?
Karen Stone, KARENSTONE.
Ms. Stone, do you know Anthony Prison?
Yes.
And how do you know him?
We have a relationship for 10 years.
Did you recognize him if you saw him again?
Yes.
Do you see him in the courtroom today?
Yes.
Can you describe where he's sitting in an article of his clothing?
He is in a blue suit.
Your Honor, record may reflect identification of the defendant.
Any objection?
No objection, Your Honor.
Without objection, the witness has identified the defendant.
Ms. Stone, on July 29, 2022, where were you living at that time?
Oh, same place I'm living now.
And what is that address?
824 Conrad Street.
Is there an apartment number or letter?
Yeah, C5.
Is that in the city of Lansing,
Yes.
Ingham County, Michigan? On July 29, 2022, did you have a personal protection order in place that prohibited Mr. Prison from being at that residence? Do you recall approximately when you obtained
Is
that?
that a yes, ma'am?
Yes.
All right, thank you.
Do you recall approximately when you obtained that personal protection order?
I think in May.
And are you aware of whether or not Mr. Prison had been served with that personal protection order? Let me answer this question. In between the date in which you obtained the personal protection order and July 29, 2022, were there any hearings with the personal protection order that you had to appear at?
No.
Were there any motions filed on the personal protection order? Do you recall?
Not that I recall.
Okay. But you do recall that there was a personal protection order in place?
Yes.
Okay. And that prohibited Mr. Prison from being at your address?
Is that a yes,
Yes,
ma'am?
I'm
Okay,
sorry.
thank you.
Now, on July 29, 2022, were you at your apartment that day?
Yes.
Was anybody else there with you?
No.
At some point, did you come into contact with Mr. Prison?
Oh, well, besides him, yeah, he's the only
Okay, and how did that contact initially begin?
one.
Had he been there all day? Did he show up at some time? Do you recall?
No, I don't recall.
Okay. Did there come a time in which you felt the need that you had to call for the police to show up to your apartment?
I don't really remember that day. Honestly, I don't remember that day.
Okay. Mrs., did you have any animals at your apartment at that
Yes.
time? What kind of animals did you
I
have?
have a cat. Her name is Diamond.
Diamond? And you had Diamond on July 29, 2022?
Yeah.
Objection, waiting, Your Honor. The witness is obviously struggling with memory, and now the prosecutor has been waiting her pretty extensively. Thank you.
Response?
Your Honor, I don't believe that last question was leading. I was confirming that she had the cat at the time of the incident with which we're talking as opposed to today.
All right, I mean, it's, the questions are somewhat suggesting a yes or no answer. I understand that, so just rephrase, I don't think you have to rephrase, but be careful as you go forward with the leading aspects of it.
Okay, thank you, Your Honor. Ms. Stone, how old was Diamond approximately?
2 months.
Approximately 2 months old in
Yes.
July?
Yes.
At some point that day, do police show up at your home?
Yes.
You don't recall how they got there? Or who called them, I should say?
I'm trying to remember exactly what happened that day, but I do recall. But I can't remember.
That's okay. When the police showed up to your home, do you recall where you were when they first arrived?
I was standing outside.
Do you recall why you were standing outside?
I had came outside. I was talking to my mom.
When you say you were talking to your mom, do you mean in person or on the phone?
In person.
Okay.
And when I came outside, that's when he came outside with Diamond in his hand and told me if I wanted to come get him and do all the balcony.
Okay. I'm gonna back you up a little bit. You said that Mr. Friesen came outside with Diamond in his hand. Was he in the same area that you were outside?
No, he was standing on the balcony
Okay,
of the part of the apartment, and I was standing over on the other side, on the sidewalk, talking to my mom, because she lives on the third floor in the next building.
okay.
And I was standing talking to her.
If I understand correctly, you were standing on the ground outside. Mr. Friesen was on the balcony to your apartment, but because it's a balcony, he's outside.
Yes.
Okay, and he had Diamond with him at that time.
He came out on the balcony, yes.
Okay. Do you recall what Mr. Friesen, if anything, was saying to you when he was on the balcony with Diamond?
He just told me if I wanted her to come get her, and then throw her away.
Throws her over the balcony? Said yes?
Yes.
Okay. Prior to that happening, do you recall if there was an altercation between you and Mr. Friesen?
Objection leading, Your Honor.
I don't believe that's suggesting yes or no, just because it is a yes or no question. It's.
I'm gonna overrule the objection. I think you've asked her if she recalls what happened, or if she recalls something that happened. So I'll allow it.
Do you recall if there was an altercation between you and Mr. Friesen?
Well, I remember I was in the room, sitting on the bed, and I was talking on the phone to my mom and my daughter at the same time. I do remember that, and then, he come in and asked me to get off the phone because he wanted to talk to me, and I told him to wait, and I'll talk to him when I get off the phone.
Objection in terms of her statements to him, which I believe would be hearsay. Thank you.
Response?
And I don't believe they qualify as hearsay. I believe they go to her state of mind at the time and her perception of the events that are happening around her.
Well, I don't know if we've laid foundation for state of mind. I do think her statements made to him at the scene are hearsay at this point. So I'll sustain the objection as to her statements to him.
Thank you, Your Honor. Specifically as to what Mr. Friesen was saying to you during this time, do you recall what he was saying?
He asked me to get off the phone because he wanted to talk to me. I told him he would, and I got done talking to my mom and my daughter on the phone.
And how did Mr. Friesen respond to you essentially saying, hang on a second, I'm on the phone?
Well, he walked out of the room and then he came back in and told me that he wanted to talk to me. I said, well, wait, I'm like, don't I'll talk to you. And then he,
Again, with the hearsay, Your Honor. Thank you.
Response.
Your Honor, I would get the same response. I believe it goes to her
But
state
we're,
of mind.
I don't know if weight is defined as hearsay, as an out of court statement not for the truth. It sounds more of a command or an indication. At this point, it sounds like this is not being offered for the truth at all anyway. So I'll allow it, overruled.
Thank you.
and then when he came back into the room, I was still talking to my mom and my daughter on the phone. And he went to grab the phone out of my hand. We were, talking back and forth. I was trying to keep him from taking the phone out of my hand. And my mom and daughter was on the phone at the same time as this was happening. And he finally got the phone out of my hand and he took it and threw it out in the hallway. I went out to get it, he locked me out. That's when I went outside and I was talking to my mom.
Now, when you said you were tussling with him to keep your phone. When that's occurring, what was going through your mind, if you can recall?
Nothing really. I was just trying to get my phone.
Do you recall how you were feeling at the time?
No.
Now, when you went outside,
Mhm.
you had your phone at that time, correct?
Yeah.
Yes, correct. And Diamond was still inside the apartment?
Yes.
During the tussling, do you recall what, if anything, Mr. Friesen was saying to you specifically?
No.
Do you remember talking to the police that day?
Yes.
Do you remember giving them a statement?
Yes.
If you were able to review the statement that you provided to police that day, would that help refresh your memory on the things that Mr. Friesen was saying to you specifically?
Yeah.
concerns.
Okay.
If I may approach.
You may.
So I'm handing you a copy of the pages of police report. If you could just read quietly to yourself that outlined paragraph, look up when you're finished. Does that help refresh your memory?
Yes.
Can you tell the court what, if anything, Mr. Prison was saying to you during the tussle over your phone? So I can move on to a different question right now. We can maybe come back to that one, okay? I want to talk to you a little bit about the setup of your apartment building. You testified earlier that Mr. Prison was on the balcony with Diamond. You say balcony, I just want to clarify. You're talking about ground floor patio, or are we up in the air?
Second floor.
Second floor. And did you witness, you said that at some point Mr. Prison threw Diamond over. Did you witness that happen?
Yes.
When Diamond landed on the ground, what was her demeanor like?
She was meowing.
When you say meowing, do you mean like a loving
No, she
meow?
was meowing, but she was big.
Okay. And as her owner, you would know the difference, or at least the perceived difference between the two types of sounds, is that correct?
Yes.
When you picked up, or did you pick up Diamond?
Yes.
When you picked her up, did you notice anything about her that would cause you concern?
Yes, her paw was like this. She couldn't walk on it.
And just for the record, when you say like this, you're having your hand
Her
simulating a
was
paw
bent like this.
bent back.
Yes.
Okay. At some point after this incident is essentially over, do you try to see if Diamond can walk?
Yeah, but she couldn't walk on it.
Were you able to treat her
Yes,
medically?
I had made her a homemade splint out of popsicle sticks, and I wrapped it up with an ace bandage
Do you recall approximately how long you left that splint on her leg?
for a little over a week.
And since that time, has the leg seemed to have healed, at least for your perception?
Yes.
And to be clear, you're not a veterinarian, is that correct?
No, no.
But at this point, what would you classify her walking skills as? How would you classify them?
She's walking. Okay, now.
Prior to Mr. Prison coming onto the balcony with Diamond, had you had any contact with him when you went outside?
What do you mean?
So at some point you go outside and Mr. Prison is presumably still in the apartment.
Mhm.
Before he comes onto the balcony, do you two have any contact?
Yeah, he called me on the phone and told me, he said, come get Diamond. And I said, she's okay where she's at. And then like a minute or two later, that's when he comes outside with her on the balcony.
When he's on the balcony, did he again tell you to come get her? Or
He
did
said,
he
if you want her, come get her. And he goes on.
When Mr. Prison said, if you want her, come get her, did you begin walking that way or?
I
no?
told him, don't do it. Don't do it.
And then that's when he drove her over. So yes.
Yeah.
Again, Diamond's your pet, is that correct?
Yes.
So I just have one final question. Do you recall what, if anything, Mr. Prison was saying to you during the tussle over the phone? Do you recall reviewing the police report?
Yes.
Did that refresh your memory? And what, if anything, did he say to you during that tussle? Did you say that he was going to kill you?
Yes.
In that moment, did you believe him?
Yes.
Okay. And nothing further?
Cross-examination.
Thank you, Your Honor. Would you like a moment, Ms. Stone? Are you ready? Would you like a brief moment?
Just a moment, please.
Okay. Sure. Okay. You said you're ready?
Yes.
Thank you. So on July 29th, 2022, was Mr. Friesen still in the lease for the apartment?
Yes.
And this was an apartment that the two of you had been living together at,
Yes.
and he had keys to the apartment.
Yes.
And how long had he been in the apartment that day? Isn't it true that he was still living with you at that time?
Yes.
And he didn't have to force himself in or anything like that, right? You let him in.
We had keys.
The keys, okay. And on that day, had you been consuming anything that might impact your memory of the events today, any alcohol or drugs or anything? Okay. Did you talk to anybody other than law enforcement about what allegedly happened here today? Okay.
I'm gonna have you speak up, man, just for the recording.
I'm sorry.
You're okay.
And with the PPO on 5/20, do you recall who served that and when on Mr. Friesen?
No.
And do you recall what time that he called you?
No.
Okay. Do you recall approximately what time this incident occurred at?
No.
And when you testified earlier about your cat being dropped from a balcony, how far were you located from the balcony at the time?
I'm not sure.
Okay,
Wasn't very far.
wasn't very far.
Mhm.
Do you wear glasses or do you have anything in terms of your vision that might have been impaired?
No.
And have you made any comments about what allegedly happened here on Facebook? or other social media apps?
No.
And do you recall approximately how long you received that phone call from Mr. Friesen versus when you were outside? You know, approximately how long that time frame was?
No.
And do you recall how long it was from when you received that phone call from when you observed the kitten falling?
No.
And to the best of you know, is the kitten is walking fine now?
Yes.
Okay. Nothing further, Your Honor. Thank you.
Redirect?
Thank you, Your Honor. Ms. Stone, in reference to Mr. Stark's question about you discussing this case with anybody, did you discuss this case with the care advocate that you have?
I forget about that, yes.
Okay.
I talked to Matthew.
Is in response to his question, did you talk to any of your family or
No.
friends?
I don't know.
Okay. And has anybody, including your advocate, told you how to testify today?
No.
At the time of this incident, the personal protection, was that still in place?
Yes.
The judge had not lifted that personal protection
No.
to your knowledge?
No.
The judge had not allowed Mr. Friesen to be at your apartment to your knowledge?
To my knowledge.
And lastly, Mr. Starks asked you a couple questions about Diamond and how she gets to be on the ground. I believe he classified one as dropped and one as fell. How would you classify how Diamond made it from the balcony to the ground?
What do you mean? Like you just dropped her on the ground. She made it on her feet.
Was an intentional act where a director said he threw her over the balcony? Was it an intentional act or was it an accident?
I think it was intentional.
And why do you think that?
Because I think he was mad because I couldn't get off the phone so he could talk to me.
That's when he brought Diamond out to try to get your attention.
I think that's why he did it.
Thank you. Nothing further.
Any cross-examination based on the redirect? I'm only indicating because I see your client writing.
But when you state you think it was intentional, that's just your perception of it, correct? He when he was out on the balcony, he never threatened to actually drop the cat at that point, correct?
What do you mean by that?
Okay. Was there any conversation between you and him when he was out on the balcony before the kitten was dropped?
So he just told me if I wanted her to come here.
That's all he said.
Yes.
Okay. And you were right near the balcony at that point, correct?
No, I wasn't by the balcony. I was standing over on the sidewalk on the other side, right on the other side of the building.
Okay. Thank you, Your Honor. Nothing further.
May this witness be excused?
So may I ask one
Sure,
redirect based off that?
sure.
Ms. Stone, your balcony, can you describe approximately what's the size of that?
I'm not sure.
Yes, is there room when you leave your?
I have on my balcony, I have a porch swing on my balcony. And then I have like a couple lawn chairs. So it's that big enough to put a swing up there, so.
So it's not a balcony in which you walk directly out and you're automatically at the railing?
No.
Thank you. Nothing.
May this witness be excused?
Yeah, sure.
From the defense?
Yes, Your Honor. Thank you.
All right, ma'am, you're excused. Thank you for your appearance today.
Thank you.
The people may call their next witness.
The people rest, Your Honor.
Does the defense have any proofs today?
No, Your Honor. Thank
All
you.
right. A motion for bind over?
Yes, Your Honor. Yes, initially, Your Honor, I'd like to address the cost for the additional count of resisting and obstructing. I acknowledge that be able to take testimony on that, so we'll not be asking for that bind over today.
All right. So as to the other counts,
Thank you, Your Honor. As to the home invasion first count, Your Honor, there is testimony both from the officer that a personal protection order was in place, verified through lien, and had been served on May 20th, 2022, that prohibited Mr. Prison from being at 824 Conrad Street, apartment C5 in the city of Lansing. Ms. Stone testified the same, that she had applied for that personal protection order, and then it did prohibit Mr. Prison from being at the apartment. While he had a key, he had previously been on the lease, he was court ordered to not be at that apartment, therefore he did not have permission. There was no way that he could have had permission. Ms. Stone could not have given him permission to be at that apartment. While he is at that apartment, Your Honor, the testimony indicates that there was a argument over the fact that Ms. Stone was apparently ignoring Mr. Prison, angering him, causing him to try to take her phone from her. During that altercation, he's threatening to kill her, to put her head through a wall, and to smother her, based on the combined testimony from both Officer Anderson and Ms. Stone. At that time, Mr. Prison is able to get Ms. Stone's phone from her, throw it into the hallway, and when she goes to retrieve her phone, he locks her out of her apartment. Ms. Stone then testified that while she is downstairs on the ground speaking to her mother, who's on a third-story balcony outside, Mr. Prison is calling Ms. Stone, telling her to come get her cat. This again is after threatening to kill her, smother her, and put her head through a wall. When Ms. Stone tells Mr. Prison that her cat is fine where she is, Mr. Prison comes out onto a second-story balcony, tells her again to come get her cat, knowing that this altercation had just ensued, knowing that he had just threatened to kill her, smother her, and put her head through a wall. And when she does not do exactly what he says, he throws the cat over the balcony. Ms. Stone testified that this cat is approximately 2 months old. It's just a kitten. And while she landed on her feet, she did appear to have an injury. The fact that Mr. Prison would throw, drop, toss, whatever adjective wants to be used there, a kitten over a balcony, in which the balcony is not one, again, as Ms. Stone just testified, that as soon as you walk onto it, you're at the railing. There's plenty of space to walk towards it. This had to have been an intentional act for Mr. Prison to even be in a position where Diamond was over the railing of the balcony to be able to be placed in that danger. Diamond is a kitten, a companion animal, as Ms. Stone testified, and the fact that this threat or this act to harm Diamond was done to control or to exert duress over Ms. Stone, again, all stemming from the fact that she was simply ignoring him because she was talking to her mother and her sister, I believe would both justify the animals killing or torturing in the second degree, or in the alternative, Your Honor, if the court does not feel that there is enough to substantiate the fact that Mr. Prison was doing this in order to exert control or duress over Ms. Stone, that he clearly was committing a reckless act by having the kitten over a balcony, in a second floor balcony, putting her in a position to which she would fall and potentially break her paw, which there appears to have been some injury to the paw, as Ms. Stone indicated she had to do a homemade splint for the cat for at least a week before she was able to walk again on that paw normally. Because of the fact that that happened while Mr. Prison was in the apartment that he was not given permission to be in, that being a felony, and because Ms. Stone was lawfully present in that home at the time that this happened, Your Honor, I do believe that that substantiates the home invasion first degree. I would ask the court in the alternative, because there's a personal protection order in place, that the court consider adding on a home invasion third degree in the alternative to home invasion first degree, not as an added count altogether, but just as in an alternative to count one. And then the domestic violence obviously is a misdemeanor, but that was also testified to as far as the struggle or the tussle over the phone, and then relationship between Mr. Prison and Ms. Stone of the 9 years with 3 children in common. Thank you.
response?
Thank you, Your Honor. Respectfully, on behalf of Mr. Prison, I'd ask the court to dismiss all these counts. For one thing, the PPO was never introduced as an exhibit, was never introduced as evidence in these proceedings. The hearsay itself contained in the PPO is something that should be noted here. The document itself was not introduced. So we don't know specifically what this document was actually describing, if the testimony here was accurate. There was talk about a PPO, but no PPO has actually been introduced as evidence for today's proceedings. And Miss Stone made it fairly clear that this was an apartment that she and Mr. Friesen had occupied together. that he had keys to the apartment, that he was on the lease. We did not get any clear testimony from her at the time that he was in there without her permission, albeit there were references to a court order that might have, had she chosen to actually try to enforce, perhaps, that could have been a question, but it was rather apparent that based on her testimony that she was either possibly ignoring the order or that the order was not being enforced at the time. Because if the order was being enforced, if she believed it was a valid order, if she was going to go follow through, then she would have immediately called, the police when Mr. Friesen appeared at the apartment. She didn't do that. Fair. On the contrary, it appears that there's some type of interaction between the two of them, or Mr. Friesen might have been able to go back and forth between there quite freely. It was hard to tell based on her testimony. It certainly wasn't very clear from her directly. Mr. Friesen didn't have permission to be in there. As for the other elements, of course, respectfully, the prosecutor has not met the burden of proof here, even though it's a very low burden of proof, which is only probable cause. In particular, as it relates to count 2, that language is very specific that there has to be some intent to knowingly kill or torture as a component of that, or knowingly it did or threatened, and as it relates to the emotional distress as well, perhaps in a light most favorable to the prosecutor, there was sufficient evidence to possibly argue for bind over on count 3, a reckless act. But respectfully, the testimony was not sufficient to bind over on count 2 here because of the very specific language that this charge requires. And of course, I'd object to the proposed amendment too, as relates to how these particular statutes, which ultimately relate to personal property, not another human being. This is a personal property issue. Ultimately, that's how these animals are treated under the law here. It could be then manipulated into the way that the prosecutor is requesting this court to amend that count. So respectfully, the people have not met their burden for bind over here. I would request that all these counts be dismissed. Thank you.
Thank you, Mr. Sart's response.
Thank you, Your Honor. I'll take my response in 2 parts if the court will allow. The first being the PPO hearsay. Your Honor, not only was there testimony on direct, but there was testimony on cross about the existence of the personal protection order, the specifics being the date that it was issued, the date that it was served, the court that issued it. Mr. Sart at no point objected to any of that being hearsay, even though there was not a physical copy of the personal protection order to put into evidence. In fact, again, he actually questioned Officer Anderson on the specifics of the personal protection order. So you can't ask during the questioning about the specifics and then at your bind over argument or your dismissal argument, ask the court to dismiss everything that was said about the PPO because the physical copy was not put into evidence. Today, the officer testified that she did verify in lien that it had been served. She physically saw a copy of the order that had the date on it. And Ms. Stone testified that she obtained a court order that prohibited Mr. Friesen from being at her apartment, and that was obtained in May of 2022, all consistent with what Officer Anderson testified that she was able to verify through lien and actually verify through her own eyes, seeing a physical copy of that order. In regards to the count 2, Your Honor, and I'm sorry, in whether or not Ms. Stone gave Mr. Friesen permission to be in that apartment, I don't know of any court order where anybody other than the court themselves can allow the defendant to do something. If that court order prohibits or restricts a respondent or a defendant from doing a specific act, the court is the only person that can then rescind that order or modify that order to allow the defendant to do those acts. A third party cannot do it. A protected party on a personal protection order cannot do it. A protected party on a no contact order cannot do it. It is a restrictive one way only, and Ms. Stone is not responsible for enforcing or whether she's ignored the order. This court is well aware there's many reasons why that may be happening. That's not an issue here today. What's at issue is that Mr. Friesen absolutely had zero ability, had zero permission to be in that apartment. In regards to the animal charges, Your Honor, and specifically count 2, we look at MCL 750.50B, and I have a copy for the court if the court would like it. When we look specifically at the second degree, I can give a copy to the court and a copy for defense counsel. And the approach.
Well, thank you.
we look specifically at MCL 250.50B, subsection 2, subsection D. It says a person shall not do any of the following without just cause, subsection D, violate or threaten to violate, subsection A or C, with the intent to cause mental suffering or duress to a person or to exert control over the person. Specifically, in regards to proofs in this case, subsection A says knowingly kill, torture, mutilate, maim, or disfigure an animal. So while Mr. Starks is arguing that animals are property, they're viewed as property, that may be so, but there are special exceptions in our law based on the type of property that animals are, that say that a person cannot threaten that animal or cannot threaten harm to that animal in order to cause duress or control over another person. Specifically, Your Honor, if we look at the torture and what that means, I have the jury instruction. It's a non-standard jury instruction, which is taken specifically from People v. Henderson, 282 Mich. App 307 from 2009. I have a copy for the court and a copy for defense counsel if the court will allow. It is non-standard jury instruction 2128. Sorry. That specifically says that in regards to animals, torture is defined as any means of act or omission that causes or permits an animal to suffer unjustifiable or unreasonable pain, suffering, or death. I would argue that a sprained, limp, broken paw absolutely would cause an animal unjustifiable or unreasonable pain or suffering. We heard testimony from Ms. Stone that that Diamond, the cat, was meowing in a way that was distressful, that seemed that she was in pain, and was not her typical happy meowing that would lead to the torture portion of that subsection. Again, if the court does not feel that there is enough, we look at MCL 750.50B, we look at subsection 4, says subsection 5, if the person violates subsection 2, other than the animal being a companion animal and the defendant intentionally killing or intentionally maiming, intentionally administering poison, or intentionally disfiguring, I think it's very wordy. For killing or torturing an animal in the first degree, it has to be a companion animal, and on top of being a companion animal, the defendant in the case has to intentionally injure by way of maiming, torture, disfigure, mutilate, or kill an animal, or intentionally administer poison to that animal. For the second degree, Your Honor, it has to be a companion animal, and the person is threatening to either maim, mutilate, torture, or kill, or threatening to administer poison to that animal. If the animal is not a companion animal, then those things can be the same and it will be the third degree. But if the animal is a companion animal, then the subsection C under 2C, I'm sorry, 2B, I apologize. 2B says commit a reckless act, knowing or having reason to know that the animal will be killed. That would fall under subsection 5, saying that any person who violates subsection 2, except as provided in 2, 3, or 4, which would be first degree or second degree, is guilty of third degree. So because this is a companion animal and because it was a reckless act, it would fall under the third degree. Otherwise, Your Honor, because it is a companion animal and because Mr. Frison in this case is alleged to have threatened to kill, torture, mutilate, or maim by holding the cat over the balcony, telling Ms. Stone to come get her cat, that would fall under subsection, again, 4, making it the second degree.
Any response?
Thank you, Your Honor. I would just reiterate my previous objections. Thank you.
Well, this is preliminary examination. It's a probable cause standard, probable cause being the second lowest standard in criminal law. Circuit court, of course, the beyond a reasonable doubt standard is the standard for conviction, in which a court would determine conviction of the case. I don't find any real dispute that of the location is 824 Conrad, apartment C5, and in venue is in city of Lansing County, state of Michigan. I believe both of those have been proven by preponderance of the evidence. Identification by the officer was first done by Ashley Anderson and then second done by Karen Stone, who's known the individual for 9 years and they have children in common. So that was easily met as identification. The date of July 29th, 2022 is easily met at a preponderance standard. So we get to count one, which is a little bit more difficult in regards to the chronological of the events and how it came in. I don't have any problem with an in or without permission in regards to home invasion here. I believe that's been met at a probable cause standard. There was a valid PPO that has been testified to by the officer. It was the premise of the officer going there was a violation of the PPO. There's been plenty of testimony that the PPO was out there present as early as June or July, June, and then on July 29th was still valid. Although it appears that Ms. Stone may have also indeed violated the order. The only thing that can replace a no contact order is another order of the court. And so I believe the defendant was easily there without permission at 824 Conrad Apartment C5. The chronological order of this is a little bit harder to ascertain, since there were events that happened inside and then once again outside, where Ms. Stone was outside of the home invasion residence. Home invasion, as I read it, requires the person to be inside the residence at the time of the committing of whatever act is out of the home invasion. So you have home invasion, you have the act, and then you have was a person armed, or was there a person present in which raises it to home invasion first. And that is gray for our purposes in the probable cause hearing. I don't think what's gray at all is that the defendant was in the home in violation of a protection order. That's not gray to me. That seems to be, but clearly by preponderance of the evidence. So in regards to count one, I'm going to bind over on home invasion 3. The defendant broke and entered or entered without permission a dwelling. When the defendant entered, was present in, or was leaving the dwelling, he or she violated a term of condition of probation or parole, a personal protection order, or a bond or pretrial release. The term of the condition the defendant violated was ordered to protect a named person or persons. That's pursuant to MCL 750.110A4. And that's through officer's testimony and the testimony of Ms. Karen Stone. That was somewhat problematic at times, but I believe that is punishable by 5 years in prison and not more than $2,000. I will bind over on an amendment. So I will add a count 5. So added count 5 of home invasion 3. 750.110A7. I also find that the facts line up for probable cause evidence to bind over on count 3, which is did without just cause, commit a reckless act, knowing or having reason to know the act will cause an animal to be killed, tortured, mutilated, maimed, or disfigured. Tortured by definition has been indicated for the record. I believe that's by preponderance evidence is very clear that's been committed. So I will bind over on the amended count 5 and count 3. You're gonna love doing the due processing on this. I do believe that the domestic assault count 4 will go into circuit court as to follow the 2 felonies that are being bound over. The court will not bind over on count 1, the home invasion first, and count 2, the animal killing, torturing, a second degree. So I will bind over on the counts would be counts 3, counts 4, and the amended count 5. And the count, for our purposes, count 4 is a misdemeanor that trails along with the 2 felonies. Any questions about the court's bind over from the people?
Just for clarification, reasoning for not bending over on the first degree is because unclear as far as the record is when the animal killing or torturing happened as opposed to when both persons were in the apartment. Is that
Yeah,
correct?
it appears that she's outside during the killing intentionally or reckless act. She's outside of the building, and it didn't happen in coinciding with her being present in the building. And although there is a domestic that's obviously, according to testimony occurring, that doesn't appear to be the underlying felony for the home invasion first.
Thank you, Your Honor.
Okay. So anything else from the people on this case
No, Your Honor. Thank
in the
you.
file? Anything from the defense on docket 220251?
Your Honor, if I just may be briefly heard on a bond motion.
Sure.
Thank you. Mr. Friesen currently still has an ongoing hearing related to the PPO associated with this. So he currently is without any bond due to that whole. But on this file, Your Honor, in light of the charge reduction after bind over, I would respectfully request a reduction in his current bond amount. He does have another pending charge. You know, the odds are, it's going to be really hard for him financially to come up with the means to even post his bonds, but respectfully, and I've addressed this issue before, Your Honor, in terms of he's not a flight risk at all. He has connections to the community. He wants to get the opportunity to try to get out and try to work, and we could have a prolonged process here. You know, he has certainly every intention to comply with the court's orders if the reduction is ordered, and I would just ask for a reduction of his current amount. Thank you.
Thank
Response?
you, Your Honor. Given the nature of the allegations and the events in this case, as well as the other outstanding felony file, and the fact that this personal protection order and the violations are currently in place, and that court I'd ask at this point not modify bond at this time. There is a personal protection order hearing scheduled for tomorrow at 2 p.m. Given the outcome of that hearing, I believe maybe the circuit court would have a better grasp on all three of the files at that time, and maybe Mr. Sorts can bring a motion to the circuit court to address bond. However, at this time, Your Honor, I believe bond is appropriately set.
Thank you. Based on the testimony I've heard today, Mr. Friesen, I'm not any less concerned about the safety of the victim or the safety of the community concerning your interactions on a valid PPO. And then the included felony count of reckless activity towards a kitten. So I'm going to deny the motion for bond reduction. It's set at 5,010%. The rest of this can be determined by circuit court after after the no contact hearing. I agree with counsel. So the bond reduction is denied. Anything else for file 220251 from the people?
No, Your Honor. Thank you.
Anything from the defense?
Nothing further, Your Honor.
All right, that's all for the record in 220251. I just sign this one.
3, 4, and amended 5, right?
Yeah, it is.
I'll make it right.
Three.
Mr. Starks, did you want the transcript?
Yes, please. Thank you.
Thank you, Mr. Starks. If you could just handle it, please, make home when you're finished. Thank you.
Three.
Okay, sign it.
750,
I got to move.
1104.
75.
11.
The issue with black is that it shows too much on the copy. It's hard to tell the difference.
I wrote a pen when we bought our house to try to sign the papers, and they were like, "You can't sign with that."
Really?
With
Show
a
me where
purple.
it says I can't.
You're right.
And they said, "No, you okay?"
I'm fine.
All right.
Just Klutzy, 2 left feet.
That's
These stairs in this courtroom. will
Not a very
be
good
every
dancer.
time. Good luck with Judge Aquilino.
Oh, thank you. Yeah.
right.
I'm sure they're just hitting lunch now, because I'm sure the morning we're around lunch, so no worries.
So are you in that court too?
I'm
No,
with Judge JMO.
okay,
So, I mean, I
All
will
right.
be for this, but
right. Well, good luck, and if I don't see you, have a nice weekend, all right?
thank you.
Thank you.
I'm so sorry again about the time today. And
Don't worry about it, don't worry about it, we weren't going anywhere. No. Generally, the question is, we stay until the files are done.
Yeah.